So I'll collect a few questions if there are any. Go ahead, Taj.
So I have two comments, one for Deb and one for Ryan. And actually this panel, although focused on human rights, touches upon the most basic, fundamental questions of telecommunication policy and law. So regarding Deb, this is something I thought about. An underlying presumption in the presentation was that telecommunications include communications via internet, which is not a trivial point. So actually on Thursday, the FCC is going to vote that internet communications are not a telecommunications service, but an information service. And therefore, this would not pertain, if I understand correctly, the ITU treaty would not pertain to a blockage or a kill switch if what it's doing is blocking ISP communications. In Israel, there's a very broad definition of what a telecommunication service in action would be, but there's a general letter that sets aside regulation of all internet telecommunication. And therefore, also one could argue that perhaps some of these actions here would not be a telecommunication service, would not be one that's governed. So this is an interesting point that might seem trivial to international law experts, but is far from trivial, especially this week in the world. And regarding Ryan's presentation, I want to point out that the discussion you carried out has been carried out almost 100 years in the telecommunication world under the title of universal service, which was not, this term was not set forth by any human rights lawyer, but by Theodore Vail, chairman of AT&T, and his famous slogan, "One country, one company, universal service," which was a manipulative way to ensure the AT&T monopoly. And so we have, I don't know, 50, 60 years of scholarship on universal service, which I think you should think about, especially recent calls to do away with universal service requirements because of the way this impacts telecommunication markets. So these are two interesting fields in general, again, that build into the presentation from a different doctrine.
Thank you. Can you please pass the mic to Altim behind you?
Thank you all.
We're going to take a few questions and then you can have some closing remarks.
So thank you so much for the talks and every one of you. I wanted to ask something, Ryan, because I wonder about your presentation and specifically about the experiment you made about the prevention as basing that on the human right of internet access. And I wondered how much is it a problem of the Western world? Because in the end, well, in Africa, someone doesn't have internet access, so why would he feel deprived of not having internet access to begin with in order for your experiment to have any effect on him? So I wonder how that will be an effective measurement for someone that doesn't have already internet access.
Sort of a follow-up on the last question and a thought for Ryan. So people may be affected psychologically in a different manner when they know that everyone else has access to the internet and they're deprived, or when no one else has access to the internet. So you mentioned that you're going to extend your experiments. Maybe you should sort of construct sort of an artificial world where no one has access. I don't know, there's a global internet catastrophe, and see whether the responses change under those circumstances.
You want to ask? Let me pass you my mic.
This is more of an observation on Antal's presentation. At least on the very superficial level, it seems that many presentations that I hear now about the situation in Ukraine, they seem to equate Crimea and Eastern Ukraine, while, you know, de facto the situation is very different because Crimea is now deemed territory of another country by this another country, and the eastern Ukraine is sort of no, of course, I mean, the United Nations has one view, Russia has another view, etc., etc. And then the situation in the eastern Ukraine is basically just an insurgence. So Ukraine has very different level of effective control over these two territories, although I don't see many scholars making this difference. But this could be a perfect case study on the different levels of effective control over the territory and infrastructure on this territory. Thanks.
Noam and then Yuval and
So I actually had a similar question to Antal, but I'll leave that aside now. The other comment I wanted to make was to Ryan. I don't have a question, but it was fantastic. Thank you.
Want to change seats?
Ryan, I wonder, you might have done this already, but I wonder if it's worth looking in comparison to the debates that have been going on for probably about 15 years now about access to energy as a human right. Because there's been a very, very similar discussion and it's been going on for a long time. So it might be possible to draw lots of analogies and learn from things that have been said there about something that is seen as an auxiliary right, that without which you can't have so many other rights, but is not mentioned in name in any human rights instrument. So and there's a lot there. And one of the ways, by the way, they've dealt with that is in the Covenant on Economic, Social, Cultural Rights with regard to the right to an adequate standard of living. It says that an adequate standard of living includes, and it mentions food, clothing, and housing, and we've accepted all of those. Now, the word includes leaves open the possibility to read more things into that. It doesn't say namely or specific. So there are some rights where you could actually read in, and that's where they read in access to energy, and you could try and read internet access in that as well. But more generally, just I thought the debate on access to energy might provide a lot of food for thought.
Thank you all. Very briefly, I have a very quick question to the three of you. So first to Ansel, I mean, are you were you suggesting that states have an obligation to exercise sovereignty over these areas, or was it merely that they have a right to exercise sovereignty? So this is one question. The second question to Deborah, to Deb. You did mention this provision on the right of states to terminate the transfer of telegraphs or what have you, with regard to, but they have to invoke a security or public policy justification. So are you claiming that the kill switch cases should be reviewed under this provision, both for the grounds invoked, so maybe the high school examination is one thing, but also in terms of proportionality? Is this any part of the analysis? And to Ryan, just to clarify, are you suggesting that this is an auxiliary right as a matter of existing law, or are you making the normative claim that this should remain an auxiliary right? I would make the case that an auxiliary right articulation doesn't fully capture what's at stake here, and I think it goes beyond that, just being an instrumental way to attain existing rights.
So, until first, I thought all three presentations were great, and I'm not saying that to be polite. Until,
What's wrong with being polite?
huh? Because I want them to know I really appreciated their thing. Because if you go to Europe, they tell you it's a great presentation, even if it's garbage. We're in Italy or in Israel. I'm telling you, there were three great presentations. Well done. That's why. So the Russia comment made me crazy. Any suggestion that is Russian territory is absolute nonsense as a matter of law. But I think as a matter of law, I don't want to discuss it. It makes me crazy. It makes my head hurt. But you make a very, very good point. And the very good point is belligerent occupation. So what you do need to do is do exactly what, but I think I would measure it against the obligations of during a belligerent occupation, which are very, very interesting, the obligations of the belligerent or of the occupant. But my question was along the same lines as Yuval's, lex lata, lex ferenda, and I wonder if you could give me a situation where, for example, the right to access to the internet would be violated, but not, for example, the right to expression. Because we struggled with this issue in the Tehilla group, and as you know, because you read it, we came to the conclusion there is no right to access, but it's very likely that if you deny right to access, that you would violate other international human rights. So same question, lex lata, lex ferenda, and if it's lex, and in either case, can you give me a situation where you would violate access but not expression?
So one more comment or question, and then we're going to let you.
Thank you very much. It was very interesting. And I have first a question to Ryan, or first a comment to Ryan. I think it's a little bit difficult to, let's say, state that there would be a right to express your opinion, receive information, etc., which is bound to a certain means of communication. Because if you say there is a right to access to internet, there must be also a right to a newspaper. And I never heard about that. And then you always have to think about the consequences. And this is what I'm wondering, whether you thought about that. Because if there is a right to access the internet, what do we do with sub-Saharan regions in Africa? So we have mass violations of human rights there. Do we need a UN resolution under Chapter 7 in order to make a military operation in order to save human rights, which are massively violated? So this all has consequences. I'm coming from the real world, not from the academia. So this is why I'm always thinking a bit practical. And then
real world.
okay.
You know you're at a university, you know.
Yeah. What, and also in these terms, what do you think of this, I would say, neo-colonialization of Africa by Facebook, where Facebook is granting free access to internet, but please under the condition that you gave them all your data, right? So what do you think about that? And this is also a question to Antal, because you say the state has to guarantee human rights, which I fully disagree with that. This is not correct, I think. So if the state has to guarantee human rights, so the state has to guarantee access to the internet, what does it mean? Does it mean that Facebook is taking over quasi-state obligations? Do they have to observe human rights then as well, as a US company? And also a question to you, if the state has to guarantee human rights, which I don't think is right. Human rights are like, rights of the citizen against their own state, full stop. Mm-hmm. And there might be some guarantees of public orders, etc. the state has to fulfill, but I don't think that it has to fulfill, guarantee human rights. But if it's true, because this was on your slide, does my state and your state has the guarantee, has the obligation to guarantee your right to privacy, and therefore stop the NSA mass surveillance somehow?
Very dramatic ending. So I'm going to start with you, just according to the order of your presentation.
Thank you.
2 minutes, and so that we can send
okay.
everyone
Thank you.
to the next copy.
Yeah, then I will mix all the questions that was addressed to myself. Thank you very much for very enriching questions and very thought-provoking questions. So, first of all, let me clarify. Due diligence, it was recognized by the case law of the International Court of Justice, both as a general principle of law. It was referred to as customary international law, customary norm of international law, and general international law principle. So if we find all of these definitions of the different understandings, but I think it is not far away from the reality if we consider it as a standard of international law, as recognized in an article of the American Journal of International Law in 1928. A standard is defined as a measure where the state has different action, which is at its free disposal, an obligation of means and not of result, but where the state has to do some positive action. So from this, if we apply this definition of standard to international human rights law, we see that it is at the discretion of the state to choose the means at its disposal, but not a discretion to to choose whether it remains inactive or active. So it certainly has an obligation to act in the protection of human rights as guaranteed and enshrined in its customary international law and its treaty obligations as far as possible. How much it is possible, very case sensitive on all these factors that I mentioned to you. All depends also on the breach, the severity of the breach, as the genocide case, the International Court of Justice recognized. And here I just refer to the case law of monitoring bodies and especially the regional court. Whereas human rights require positive action, it is a guarantee. So guarantee in the sense of protection against third-party violations. And here, against in the how much it works in the cyberspace, again, very much context dependent, very much dependent on your actual infrastructure or actual cyber security means. I recognize that, admit that the difference between the UK, US, and other states is huge. And the last question, belligerent, difference between Ukraine, Eastern Ukraine, very clear. I just I never mix the two. Very different discretionary means at disposal of the state of Ukraine, but the violations on the ground are very similar from different actors, of course. So restriction of freedom and belligerent occupation, very interesting question. Thank you.
So I had I think two questions. First Tal and then Yuval. So Tal, I think I understood your question as to what the how different countries may take the definitional scope of telecom to different places. So I'll be really brief. First of all, the U.S. is really an outlier in this stuff. So just the FCC has all kinds of interesting decisions, but until the United States, let me just go back and say one of the things that I find really interesting about how the ITU treaty law has kind of panned out in its influence in terms of definitions of how telecoms look. Over 100 countries in the world have the exact same definition of telecom that you saw up on the screen. So it's translated into Hebrew in Chok HaTikshoret Bezek V'Shidurim, word for word, and the same for U.S. law. On the international plane, domestically, countries decide what they do. That will have an influence on whether, to your point, whether a certain kind of communication is included in the scope of their international obligations. But internationally, and good luck separating out international telecommunications and international cyber-enabled communications at any given physical state border. So inside the United States, maybe a different definition will work. Once a single communication crosses the border into Canada, Mexico, or anywhere else, we're already in the realm of the international definition, which stays really identical for over 100 countries. So regarding Yuval's point, I think it's a really interesting coincidence or closeness of processes that the criteria in 1903 and the criteria in the 1865 ITU predecessor constitution are pretty much in the same ballpark. So we have very similar criteria. It's a point to be researched, really, whether there was any kind of checking in for 1903 to see whether there was any reliance on that. And I'll take a look at that. That's really helpful. And I agree with you. There also has to be an addition, probably on the domestic level in terms of proportionality, necessity, et cetera, et cetera. So I guess the short answer is yes.
Thank you for the comments. Firstly, the comments about a universal service and access to energy are well noted. So thank you for that. About the comment about the psychological response to internet deprivation if you're not surrounded by other people that are also connected, when I'm not speaking with the legal room, this is the most frequent comment that I get. It's some form of outrage, because when we think about being deprived from the internet for a day or two, it sounds like a luxury. That sounds wonderful to have no connection for a little while. And the answer is yes. I don't think that deprivation for someone in the Amish community would entail any negative psychological consequences. The same with observant Jews on Saturday. Being disconnected for a day when you're surrounded by other people that are disconnected is by no means negative. So we do need to put that somewhere in the model, the variable of how the people around you are. The other question, before I get to your question, was about this being a problem for the Western world. And there's a rich literature in the legal sphere about the nature of how human rights need to be manifested in countries that don't have the resources. Do you need to provide education for the entire population when you don't have the resources to provide security or liberty? So I think internet access still does have some role to play here, but it becomes a moot question, mainly because with the rate of internet take-up in the world, it's only a matter of time with the growth that we're seeing until internet access is completely pervasive and until people rely on internet access, and then it will apply to them as well. So I think the model still applies. And even within that, the nature of what access needs to be provided is different according to different countries. There was a famous court case in Norway, was it, with the mass murderer Anders Breivik, who was sent to prison for murdering 77 people, and he sued the government because the internet access in his cell wasn't fast enough, and because he only was given a PlayStation 2 and not a PlayStation 4. And he claimed that this deprived him of his right because he required that level of technology. Now, it was dismissed, but it was entertained. So the level of what's required for internet access, for general access and communication tools, is different according to the country's development. Now, regarding your question, the short answer is no. I can't imagine a scenario where access is violated, but that it doesn't affect expression. I think that internet access doesn't have any value unto itself as a human right. The only reason why we talk about it, the only reason why it has value, is because it's so intertwined with the primary rights that its deprivation affects a whole sphere of different social activities. So if it didn't, if we were to find that internet access as a tool to realize your rights was only transient, that it was going to be overtaken by another technology, then internet access would lose its status as a secondary human right. But the reason why I'm claiming this is I don't think that it's transient. I think this is changing the paradigm. I think that it's changing the nature of the rights, and that's why we can even have this discussion about whether internet access could be a human right.
Is it lex lata or lex ferenda?
I'm ashamed to say I don't know you. You broke your own rule about embarrassing the speakers.
Is it law today, or is it where you anticipate the law will be going? I apologize.
It's between both. There are arguments. We could argue and we could disagree on whether it's there today, but I claim that it definitely will be there eventually.
Thanks.
So interesting. Thank you so much. Perhaps one question that would connect us to the discussions this afternoon. You were talking about cyber vulnerability as a notion, and I really liked it, but you spoke about digital divide, cyber attack, network shutdown, and criminal punishment. And I was wondering, where would you put the chilling effect, which is a derivative of massive surveillance and its outcomes? And also, perhaps, where would you put the informal, what we call censors conversation, where without any legal basis, but with threats to regulate the platform, for instance, governments and platforms cooperate to, let's say, withdraw content from the internet. So those perhaps are things to think about. Thank you all, and enjoy your lunch. No lunch? Oh my God. 10 minutes. Okay, so you'll have to wait a little bit more. I'm sorry about that.
Congratulations.